the other day in the banquet hall, I just give you this small slip of paper.
Yes.
Though it's a slip of paper,
Yes.
it contains a lot about the Mala Fridays being committed in this organization.
This matter is now seized by the High Court. I've read in the papers.
Sir,
The matter is seized by...
yes, I do come to that point, sir. I do come. It was on the Friday last. Justice Reddy, hearing the matter including Billappa, they observed we are dealing with only 156 acres. It's another landowner. 156 acres only we are dealing. So 33 acres. How is it? 33 acres, what is been farmed illegally in agricultural land without acquisition, which has been prohibited under the Land Forms Act and under so many other acts which Ram Swami has gone into, which matter I am going to come. The second part, as you said, the matter is seized before High Court. High Court, the bench says, this is between the society versus the BDA, CMC and the particular persons. Now it is not as like the Supreme Court has given under Article 144 to do complete justice, that provisions of certain things are not available for the High Court. And third point, as the case involves of corruption by the government officers, corruption, which as per the charter of this Lokayukta, the recommendations for appointment of Lokayukta at the state level is, as indicated in that report, was made to improve the standards of public administration by looking into complaints against administrative actions, including cases of corruption, favoritism and official indiscipline in administrative person. It is the same recommendation which made the state legislature to enact the Lokayukta Act, for so on and so forth. Now corruption, and this is to supplement the existing already the institutions like the High Court and Supreme Court or such other judicial bodies. Now, I am still at the answering the first question you raised, that it is being seized of the matter in the High Court. The third part is what you say. The third part deals with the Lokayukta, who started investigation in 1999. It found, it wrote to BDA in 1999 whether the layout is approved by BDA. BDA said very strongly, very cleanly, what is the fact, it is not approved. Then further, there was another question whether the layout is been directed to be handed over to CMC. The BDA categorically said no. Then there was no direction for the BDA as what you should have done. Neither but BDA asked what should we do as per this law. This is what is the mandate. Now, this is the whole correspondence between the Lokayukta and the society. Except BDA's one letter, I think there is a quite lot in the investigation file in this particular file from CMC. Unfortunately, having the BDA wrote the letter, the Lokayukta did not direct it the way you in Turali case you directed Jamdar to investigate the matter. Another retired forest head to investigate, and you passed an astonishing order, and wonderful things worked very fast. One direction, a modified direction, unconstitutional, beyond the jurisdiction of the Lokayukta was issued by the Lokayukta to hand over the layout to the CMC.
That should be challenged in the High Court. I have no power to review this.
Yes, you have under the General Clause Act in the similar manner. If the Lokayukta Act does not allow the Lokayukta to act contrary to the law.
Not that way. See, a review power is a power which should be specifically given by a statute. Otherwise, it is not possible for me to review my predecessor's orders. If that be so, I think there will be a number of applications before me saying that you review the previous your predecessor's order.
Not even necessary, sir. You need not review it. On the face of this thing, which is part of the annex.
Yes, yes.
In the court, the BD has filed countering this order that the layout does not come under CMC, which direction was given by Lokayukta. It does not come under.
Yes.
So they have, this obstacle is also overcome here.
Okay, then the issue is there.
Now, 156 acres. What has become, this layout is not an ordinary, it's not an ordinary transaction. The land we have used as a guinea pig for our investigations. Second, really speaking, I have no vested interest in neither land nor this person's lands, or the judges whether they are benefited legally or illegally. We have taken this case to investigate the quality of justice system in India. We have used the judicial records to prove what is the level of the justice. And we interviewed A.T. Ramaswamy. He said, yes, this is a burning issue. It's a shameful issue that the judges are in a rat race to knock their sides. Judges are neither are in a position to realize that what's the status of that layout, whether it's all made in accordance with law, whether the judgments are being taken in accordance with the facts. The facts are being revealed. Now, what Reddy Ben says, certain aspects we are not going to take up. What is being in the writ petition? Produce the layout plan before the court. So that is where he is being seized of. The other things he has said openly, 33 or 37 acres, what is being illegally they have formed the sites will not. Now, the second part of my submission. This layout has become a laughing stock in the legislature, which is already discussed in 2005 in the Assembly. Which layout appears in the same, like that Durale land case, how it was referred to you. In this, this society stands at the request number 2 among the violations made.
Yes.
I wish not to the legislature upon whom you have the control of supervising their actions and inactions, including their the assets and liabilities. This legislature, we wish not again to comment or criticize the Ayukta. If after having found prima facie evidences are there that there are factors of corruption are involved, factors of conspiracies are involved, factors of law violations are involved, either in tandem or under the coercion of the judges who are allowed this. If this is not reopened, the case itself was being closed earlier. Suo-moto it was initiated. Now suo-moto it was initiated and suo-moto they closed. Now the